Listen to this 11-minute comment on this article. Share the gift. The risk was high. Federal judge in Texas known for his anti-abortion views was presiding over a lawsuit seeking to revoke government approval of key abortion drug and block access to the drug in every state. Enjoy the full WP experience. Choose your plan. ArrowRight Washington State Democratic Attorney General Bob Ferguson has launched a countermove by suing the federal government to increase access to the same abortion drug. The legal maneuver took place dramatically on Friday evening. U.S. Judge Matthew J., a candidate for President Donald Trump, less than an hour after Kacsmaryk blocked approval of abortion drug mifepristone by Food Drug Administration. U.S. District Judge Thomas O. Rice, nominated by President Barack Obama, ordered FDA to maintain status quo and maintain access to drug in 17 states of Colombia. The extraordinary 1-2 punch triggered an extraordinary legal conflict that would almost certainly be ruled by the polarized U.S. Supreme Court. It offers real-time window into how liberals are trying to counter flood of conservative lawsuits in federal judiciary reshaped by Trump, and how the political right is using single-judge court districts to advance highly conservative agenda. Conservative groups in Texas that have sued the FDA have carefully selected Kacmaryk, a lifelong anti-abortion advocate, to hear their case. And the coalition of Democratic state prosecutors responded by taking a rare step, such as suing the Democratic Biden administration for demanding fewer FDA restrictions on access to abortion pills in their states. One reasons for my decision to make a decision here state Washington is that I cannot put fate women's reproductive rights Washington hands a single judge Texas appointed by Donald Trump, whose views on reproductive freedom are good. It's known and unfortunate, Ferguson said in an interview on Friday night. About Kacsmaryk's order, he said, I felt this was coming. Lawrence Gostin, a professor of global health law at Georgetown University who lobbied for the Biden administration to protect access to abortion, said he found both cases problematic because he believed the FDA had undermined its authority to evaluate and approve drugs. She expressed particular concern about Texas case, which sought to subvert the approval of a drug that had been on market for over 2 decades and was one of 2 drugs used together to end pregnancies. But he said both decisions could politicize the FDA and have far-reaching implications beyond mifepristone. Partisans are weaponizing the system of public courts, and the victim is science and public health, Gostin said. I disagree with both decisions, but I think the Texas decision is far more radical and far more comprehensive. Rice rejected a request by Attorney General's office to issue a nationwide injunction that protects mifepristone, and applied his order only to liberal states that opened case. In response, Kacmaryk issued a nationwide injunction that blocked FDA approval of the drug. However, it does not take effect for 7 days and gives the Ministry of Justice time to appeal. Right-wing US 5. If Appeals Court of Chamber does not allow FDA to maintain mifepristone's approval until Kacmaryk's decision is concluded, legal experts say it is unclear how 2 conflicting orders will result. Experts said such a situation could increase liberal pressure on the Biden administration to tell the FDA to ignore Kacmaryk's decision. Ferguson and other Democratic chief prosecutors, who filed the Washington state case, said they would expect the FDA to retain access to mifepristone in their own states, even if both decisions were banned in other states. In interviews, they admitted that they were suing, in part, in order to blunt the impact of Kascmaryk's decision on their state. Oregon Attorney General Ellen Rosenblum said, absolutely. The FDA will have to follow the court decision in the case. If they reach Court of Cassation, conflicting cases, judges, Roe v. It will face its biggest test of access to abortion since landmark decision they took in June to break abortion rights guarantee provided by Wade. A key player, Judge Brett M., who voted mostly to overthrow Roe, but who wrote with a disagreement that he did not see the decision as limiting in states seeking to provide abortion options. Maybe Kavanaugh. At heart, both Texas and Washington lawsuits, plaintiffs question whether FDA followed scientific evidence when it determined how to regulate mifepristone, one of 2 drugs used in more than half all abortions in United States. The Texas case argues that the drug, which the FDA has repeatedly found safe and effective, should never be approved. Abortion providers have said that without mifepristone, they would either perform surgical abortions only in states where it is legal, or offer drug abortions using a single drug protocol, which, according to experts, is also safe, but cramping and bleeding than before. Mifepristone is also used. Timing and authority. Judges often do not comment on cases beyond their judgment, so it is difficult to pinpoint how and why Kacsmaryk and Rice's views have come so close on Holy Friday. But legal experts say this type of timing is extremely rare and probably not coincidental, creating the perception that opposing decisions are driven by politics. Rice asked skeptical questions Democratic Attorney General during a 40-minute hearing on March 28 in the Washington state case, which aimed to make it easier to distribute mifepristone patients. In ruling, published 10 days later, a fairly quick turnaround even for a judge known for his swift move, Rice refused order FDA to lift existing restrictions, but also banned government from further restricting access drug. In her own opinion, Rice accepted Texas case and said the Attorney General would reject a nationwide request for injunctive relief in part because of Texas case. Kascmaryk held a 4-hour hearing in Texas on March 15 about his case, announcing his decision a little over 3 weeks later. Democrats and legal analysts have accused conservative groups of accusing the Texas case of judge shopping, saying they strategically applied to Kascmaryk's single-judge courthouse because they knew he would sympathize with Kascmaryk's cases. Rising from the conservative law group First Liberty Institute, Kascmaryk joined the federal chair in 2019. The proportion of asylum seekers returning to Mexico while waiting to be processed. Before becoming a federal judge, Kacmaryk served on the board of directors of Christian Homes and Family Services, an organization that provides housing and adoption services women in order to provide an alternative abortion. The language of his rule, Friday, reflects the terminology used by anti-abortion activists, calling abortion providers abortionists and referring to fetuses and embryos as unborn people. Legal experts say filing in single-division courthouses is contrary to the random appointment of judges, a principle of the American judicial system. Texas.